All right, today we're jumping into a huge Supreme Court case from Canada that really gets to the heart of a major conflict in our justice system. On one hand, you have the right to be presumed innocent. On the other, you have the need for all of us to have faith in that very system. And this case asks a really tough question. Can public outrage ever be enough to keep someone locked up before they've even had a trial? So our story kicks off back in 1999 in Sault Ste. Marie, Ontario. And it starts with a crime that was so brutal, so horrific, it sent a shockwave of fear through the entire community. The details were just gruesome.
You know, it didn't take long for the police to zero in on a suspect, a man named David Scott Hall. He was charged with first-degree murder, and this wasn't just some shot in the dark. The case the Crown had against him looked, well, incredibly strong.
I mean, look at this. The forensic evidence was just stacked against him. His blood was found inside the victim's home. Bloody footprints at the scene, they were matched to his running shoes. And get this, there was security footage of him wearing those exact shoes on the night of the murder, shoes that he had specifically denied wearing to the police. So, with a case this powerful and a community justifiably terrified, a huge question came up right away. Should David Hall be released on bail?
This decision landed on the desk of the bail judge, Justice Balan, and it was a really tough call. He had to follow a specific part of Canada's criminal code, which lays out the very few reasons you can actually deny someone bail. Okay, and this is where things get really interesting. The judge went through the list. First, was Hall a flight risk? No, the judge didn't think so. Second, was he a danger to public safety? Well, the judge believed that with the right conditions, any risk could be managed. So based on the two main reasons for keeping someone in jail, Hall should have been released.
But he wasn't. The judge denied bail. And he did it based entirely on that third, much vaguer reason. His argument was that because of the sheer brutality of the crime, the strength of the evidence, and the very real fear in the community, letting Hall out would just shatter public confidence in the justice system itself.
And that decision, right there, raised a massive constitutional red flag. Can you really deny someone their freedom based on what the public might think, even when they're not a flight risk or a direct danger? This question was so fundamental that the case of David Hall was fast-tracked all the way to the Supreme Court of Canada.
Now, once it got to the highest court, the justices were completely split. We're talking a major clash of ideas here, with Chief Justice McLaughlin leading the majority opinion and Justice Iacobucci leading a powerful dissent.
So the heart of the matter was this. Was this law actually a clear guide for judges, or was it just a blank check? The majority said no. It's workable. It gives judges specific things to look at. But the dissent completely disagreed. They said, hang on, this is just a sneaky way of bringing back an old, vague rule that allows for a standardless sweep. Basically, decisions based on fear, not facts.
The majority's argument was pretty compelling. They argued that for the whole system to work, people have to believe in it. And in some very rare, very extreme cases, releasing a suspect could do so much damage to that public trust that the entire rule of law could be at risk. For them, this wasn't about a popularity contest. It was about protecting the very foundation of the justice system.
But the dissent came back with a chilling warning. They argued that this kind of law is just asking for trouble. It opens the door for bail hearings to become trials by public opinion, where media hype and what they called irrational public fears could end up being more important than a person's fundamental constitutional rights. See, they had a fundamental disagreement about what bail is even for. The majority saw public confidence as a crucial part of making sure the bail system actually works. But the dissent said, nope, bail has two jobs, and only two jobs. Make sure the accused shows up for trial, and keep the public safe until then. Managing public relations has no business being in that equation. So who won?
Well, in a super close 5-4 decision, the Supreme Court came back with a really clever answer. They didn't just say yes or no. Instead, they basically performed legal surgery on the law, and in doing so, they changed Canadian bail law forever.
The justices zoomed in on the exact phrasing of the law, and they actually found some common ground with the dissent. They agreed that the first part of that sentence, on any other just cause being shown, was the problem. It was just too broad, too wide open. And here's their brilliant solution. They just sliced it right out. They struck down that open-ended part, calling it unconstitutional. That was the standardless sweep the dissent was worried about, and the majority agreed. But, and this is the key, they used a legal tool called severance to keep the second half of the law. It was a perfect compromise. So what it means is that judges can no longer deny bail for any old reason.
But they can still deny it to maintain public confidence, but only if they follow a strict set of factors laid out in the law itself.
So you might be thinking, okay, that's a neat legal trick, but why does it matter so much today? Because the framework that came out of R.V. Hall is still the law, and it's used in bail courts across Canada every single day.
What this ruling really did was create a safety valve. It confirmed that, yes, there is this third reason to deny bail, but it's an extremely narrow one. It can only be used in those truly exceptional cases, the ones that would genuinely shock the conscience of a reasonable person. And crucially, it requires the judge to base their decision on objective things like the strength of the case and the seriousness of the crime, not just on public fear.
So in the end, this case leaves us with a question that our justice system still struggles with all the time. How do you protect one of our most important rights, the presumption of innocence, while also making sure that people don't lose faith in the very system that's supposed to protect us all? It's a balancing act that is anything but easy.